Domain name disputes are happening more and more every day. In today's show, you're going to learn everything you need to know about the uniform dispute resolution process for domain names from a domain name intellectual property expert. But first, these messages from our sponsors. Managing multiple domain name marketplace and auction site accounts is a pain. Inevitably, you forget to sign into one and you lose a great domain, or worse. Now imagine using a single, simple to use and comprehensive control panel to manage all of your accounts. That's Protrata. You can set up search filters, analyze domains, automate bidding, list domain names for sale, buy domains across all major marketplaces. Protrata also has a new semantic engine that builds Google-friendly websites with rich content and network feeds. Sign up at protrata.com to get 20 free credits and start building and monetizing your domains today. Finally, if you have questions about domain names, where should you go to ask them? The answer is dnforum.com. Not only is DN Forum the largest domain name forum in the world, it's the best. You can learn about domain names and the industry, buy and sell domain names, talk about the domain name news that's happening in the industry, and even meet domainers just like yourself. Register for a free DN Forum account and begin advancing your skills and knowledge today. And when you do sign up, send me a friend request so we can connect on DN Forum. Here's your program. Hey everyone, my name is Michael Seiger and I'm the publisher of DomainSherpa.com, the website where you come to learn how to become a successful domain name entrepreneur and investor directly from the experts. Businesses and individuals are coming forth in record numbers this year, charging one another with domain name copyright infringement and trademark violation through an action known as UDRP, or Uniform Dispute Resolution Policy. Anyone can pursue possession of a domain name they believe is legally theirs. But a UDRP action isn't always clear-cut, and the results often confuse and disappoint. Today we're joined by a past Sherpa, David Weslow, partner at Wiley Ryan LLP, who specializes in litigation and transactions involving trademarks, copyrights, and domain names. Full disclosure, David is also one of our sponsors. I invited him here not because of his sponsorship, but because of his IP expertise and his willingness to share with the Domain Sherpa audience and help us all learn more about this topic. And before we get started, I want to also be sure to provide a disclaimer that David is here as a guest, providing general information, not offering specific legal advice or counsel. Be sure to consult an attorney for any specific legal questions you may have. David, welcome back to the show.
Hi, Michael. Thanks for having me back on.
It's great to have you back. When you were last here and that interview aired, I went back and looked it up, July 26, 2011. We discussed a broad range of important legal topics for domain name investors and developers, like buy-sell domain name agreements, trademarks. We talked about auto-blogging software that's popular on WordPress sites and how that can get you into trouble. We discussed UDRP issues and lawsuits and much more. For anybody that wants to go back and watch that interview, go on to the right-hand side of the Domain Sherpa window, and you can see past interviews, and scroll down, you'll see David Weslow's name listed there. Actually, twice. He discussed legal issues. You discussed legal issues, David, and then we had you on discussing the ICANN 41 conference and how the gTLDs were coming out. So today, I'd like to explore the anatomy and forensics of a UDRP action and how domain name investors and developers can position themselves in case they're involved in one or they need to start an action. So here at near the end of 2012 or entering the fourth quarter, it seems like a record year for UDRP actions from at least my perspective. It seems like they're in the news all the time. Do you have any data around the number of UDRPs that have been filed this year?
Sure, and I think we're going to talk in more detail about there are 4 service providers for the UDRP. Not all of them release their statistics on UDRP filings, but the largest service provider is the World Intellectual Property Organization in Geneva, or WIPO. WIPO does release its statistics, so let me look at them here. Year to date for 2012, there have been 2,072 UDRP filings with WIPO. For the entire year of 2011, there were 2,764. So with a number of months left in this year, I think that does support your feeling that we are probably on track for this to be a record year and probably the highest year since the advent of the UDRP, particularly when we consider this is data from just one of the providers.
Yeah. And what do you attribute this increase in UDRPs to?
You know, I think it really comes down to two things. The first for me is that domain names are increasingly in the media. There's more attention to domain names. They're becoming more mainstream through GoDaddy Super Bowl commercials, through other things that you see more in all of the news about gTLDs as another example. More and more people are learning about domain names. So I think on the one hand, that leads to more people beginning to invest in domain names, people that may not have been aware that you shouldn't register a domain name that conflicts with a trademark. Whereas folks such as yourself, who are experts in the industry, learned that years ago. And you know, in my opinion, there was a dip a few years ago in those types of really direct match domain name registrations where it was clearly a trademark. I think there are more people entering into the industry, so there are more of those types of registrations. And then I think the second piece of that is as domain names become more accepted or more and more companies learn about them, we're seeing online branding and e-commerce become more and more important for companies. So they're looking at their online profile, they're looking at, well, how is their name being used? Are there any domain names that they should own? And as e-commerce becomes more and more appropriate, then we're seeing more companies file UDRP actions. And I think we can talk about this in more detail, but I've also noticed as part of the uptick, and I think you'll probably have questions about this, it seems like there are more and more UDRP rulings in favor of the respondent, which I don't have any data to support, but I've observed that as well. And I think that comes from attorneys, parties using the UDRP who may not be as familiar with it, who may not realize that it is designed to address a particular problem, clear cyber squatting. It's not really intended to address business disputes or other types of legal claims. And so when that type of claim is asserted in the UDRP, the panelist is going to rule against the complainant. The other scenario I've seen is that we've seen UDRP filings by companies that are not attorneys. I'm aware of one UDRP decision that pointed out that the complainant's arguments look like they'd been assembled by an automated computer process. Well, you can guess that the panelist ruled against the complainant in that case. So, you know, those types of filings are, in my opinion, also leading to more of these decisions in favor of the respondent.
Okay, so we're going to get into all these cases where it's cut and dry, where it's gray, where it's cut and dry the other way. But so let's talk about the UDRP process. The main purpose, the reason why there is a process called UDRP is to prevent what?
To address clear-cut cases of cyber squatting.
What does that mean? Give me an example. Like if I'm Amazon.com, what would a clear-cut case be?
If someone registered Amazon sale.com and used it to display a website that looked like Amazon but wasn't really someone that, when they registered that name, they did that for the purpose of capitalizing on the similarity between the domain name and the trademark, and then they put up content that showed that was with bad faith. So there are three requirements for the UDRP. The first is that the domain name must be identical or confusingly similar to a trademark in which the complainant has rights. The second is that the registrant has no rights or legitimate interests in the domain name. And then the third is that the registrant registered and used the domain name in bad faith. So those requirements are very similar to a federal court cause of action for cyber squatting, but the UDRP was put in place to provide for a more efficient, streamlined process. something outside of court litigation, where you don't have the ability to request monetary damages as you would in a typical court action, but you do have the ability to request a transfer of the domain name.
Gotcha. So it's similar to the cyber squatting laws that are in place, but you don't have to go to court, so it's a lot less, costs a lot less, and probably takes a lot less time. It's like arbitration. If you get divorced, instead of going to court and fighting over possessions and stuff, you can go to arbitration, try and get it done more quickly, more painlessly. But you got to prove three things. That if you're complaining, if you're the complainant filing a UDRP, you need to show that it's the domain name is confusingly similar to a trademark, to your trademark. If you're what's the complainant is the person filing the UDRP,
right?
And then the respondent is the person responding to the UDRP process.
Right.
Okay, so the respondent needs to show that the complainant, the person that's putting the complaint in, needs to show that the domain shouldn't be somebody else's, that it should be theirs, because the domain name is confusingly similar to one of their trademarks, that the respondent has no rights to use that domain name, and that they're using it in bad faith. So, for example, if I registered AmazonSale.com and I put up a website that was similar to Amazon's in color, and I was just gathering email addresses for a spam campaign or something, I could show that they're using my colors, they're using my name, they're using it without our permission, they don't have rights to do that, and they're using it in bad faith, trying to get domain names because people trust Amazon, or get email addresses because people trust Amazon. And so that would that be enough to prove for me as Amazon that that domain name should be mine?
Presumably. So you'd have to do that through legal arguments and establishing all of those facts, looking at the registration date of the domain name, establishing when your trademark rights arose, establishing, how the domain name was used, and that there was actual registration and use in bad faith. Yeah.
Okay, that makes sense. All right, so it seems pretty cut and dry, but there are UDRP cases that seems like almost every day that aren't as cut and dry as that. Maybe that the domain name is confusingly similar to my trademark, but the person that's using it, like DomainSherpaSucks.com, is saying, it's a news source talking about how I'm doing wrong for, people out there. In which case they might have a right to then use that, because we've seen a number of websites out there that have trademark words within their domain name, and then the word sucks, and they're using it as a news source or something like that, right?
Right. So your example, there are a few issues there. The first is, would adding whatever that term is to the domain name itself distinguish the domain name from the trademark? I know there are UDRP decisions that find where the domain name itself conveys something. So DomainSherpaSucks.com is probably not you. So there are UDRP findings that that's not identical or confusingly similar. That can cut both ways in the context of a sucks domain, but you get the idea that if some word is added, you have to look at, is the domain name still identical or confusingly similar? Then in the context of a criticism site, such as you mentioned, you look at, under the second prong of the UDRP, you really have to look at, well, does the registrant have rights or legitimate interests? You look at things like, is it a real criticism site, or
right.
is it just a fake criticism site to run ads, things like that. Exactly. And then, the real fight very often is that third factor. Was the domain name registered and used in bad faith? Very often, the panelist will look for arguments by inference as to what the intention was at the time of the registration. In the UDRP, you have to establish bad faith registration and use. So you really, as a complainant, you need to address that fact. Well, what was the intention at the time of registration? Yeah.
So now we can see where the gray areas sort of creep into this issue, because, somebody else may have registered DomainSherpaSucks.com and then immediately put up a parked page that had advertisements for domain name sales, as well as a big buy it now price. And they may have emailed me saying, hey, Mike, do you want to buy DomainSherpaSucks.com? I've got it available for sale. So they've shown bad faith that they may have registered it for their profit off of my trademark. But what happens if I reject it and then a month later, David, they say, now I'm going to create a true criticism site? You know, they originally had bad faith, but now they're actually using it as a criticism site. You said that I as the claimant need to show that they registered it in bad faith and are currently using it in bad faith.
Yeah, so that it's probably one of those gray cases that you were talking about. The majority rule in UDRP cases is that you must establish bad faith registration at the time of the domain name registration and then use. If there are issues such as in that case where you may have intent at the time of registration but not later, it's going to depend on really what's happened. One thing that's clear is if under the UDRP, if there was not bad faith intent at the time of registration, the majority rule is that's not appropriate for the UDRP, and that most typically comes up where the domain name was registered prior to a trademark coming into existence. Mm-hmm. The majority rule is that, well, if the trademark didn't exist at the time of registration, you cannot have had bad faith at the time of registration. Now, it's important to keep in mind that's different than a rule in U.S. court or for a cyber squatting claim. Depending on your court, there may be a rule that bad faith registration for a cyber squatting claim can come up after use, but in the UDRP, going back to your initial point, it was set up to just address a narrow type of cases, just clear cyber squatting cases. Gotcha. You've got to have both bad faith at the time of registration and use.
All right, so now we're seeing a little bit more about the intricacies involved in trying to file a UDRP case and defend a UDRP case. So Wayne Nelson, our show producer, spoke to you before the interview, and he determined that you were receiving a daily WIPO report that outlines the latest UDRP actions. Is that an email that you receive on a regular basis?
Yeah, so both, we talked about WIPO and the other large service providers, the National Arbitration Forum, or NAF, in Minnesota. There are actually 4 ICANN accredited UDRP providers. Mm-hmm. In addition to WIPO and NAF, there's the Czech Arbitration Court and the Asian Dispute Resolution Forum, I believe is the name. But there are 4 providers. Mm-hmm. NAF and WIPO, I think, handle 95% of the cases. Mm-hmm. And both WIPO and NAF do send out a free daily report of their rulings. Okay,
so if people want to get an email to just browse through, they can go to either the WIPO website or the NAF, the National Arbitration Forum website, and sign up to receive daily decisions.
That's right.
Okay, great. And so when would, how do you differentiate the difference between WIPO and NAF, National Arbitration Forum?
So the filing fees are a little bit different between each of the two organizations, and each has their own supplemental rules that can differ a little bit in how the procedures are conducted. The best example is that if a case is settled by an agreement between the parties before a panel is appointed, then WIPO will refund a portion of the fees. And that says that clearly in their rules. NAF, I do not believe, has a similar rule. Of course, as I mentioned, WIPO is based in Geneva. Its panelists, I don't have any hard data, but they seem to be more private practice attorneys. NAF seems like it's both private practice attorneys as panelists, but also retired judges. I think WIPO handles a few more cases than NAF, but again, the 2 of those organizations make up the bulk of the rulings.
So let's take a couple of scenarios. If I am a business owner and I have a registered trademark with the United States Patent and Trademark Office, and there is a website that has sprung up that is using a domain name that's confusingly similar to my trademark. I believe that they have no rights and that they're using it in bad faith. Is it more advantageous for me to file with WIPO or with NAF?
You know, it depends a little bit on the specific content that's put up on the website. If it's clear cut, then there's probably not a whole lot of difference. There are a few points of distinction on some substantive issues between the two service providers, but there's also a lot of crossover between the panelists of the two organizations. As I mentioned, the supplemental rules differ a little bit, particularly with regard to supplemental filings and the refund option if the case is settled. It really, every attorney I think that practices in this area has one that they prefer over the other. It can be just a preference for how their e-filing system works, or if the supplemental rules of one provider address a particular issue that you think may come up, such as you really want to make sure that you clearly have another bite at the apple to file another argument, then that may suggest you want to use one provider over the other. There occasionally, I think, there can be tendencies on substantive issues where you might see a little bit of a difference, but you'd have to tease that out based on the content of the site in question.
So NAF being located in the U.S. and WIPO being located in Geneva, if I'm a U.S. company, do I have any preference over NAF over WIPO? If I'm an international company, WIPO over NAF?
Not really.
No.
Everything's electronically filed. You never have to visit WIPO in Geneva or NAF in Minnesota. So it's everything's e-filed these days.
Yeah. Okay. And on both of those options, if I'm filing, do I have the opportunity to select the number of panelists that are reviewing my claim?
You do, right. So you can opt for a 1 or a 3-member panel.
Okay.
And if you're the respondent, if the complainant started with a single-member panel, you have the option to opt into a 3-member panel. Okay.
What are the advantages, disadvantages of having a 1-member panel versus a 3-member panel from both the claimant and the respondent point of view?
The biggest advantage from the complainant's perspective in having a single-member panel is the cost. So it's going to be less expensive. You aren't paying those additional panel member fees. From the respondent side, a 3-member panel, if you, based on your arguments in your response, you may think that 3 people looking at the issues may give you a better chance than just having one. You may also want to, depending on the supplemental rules, there's a mechanism for proposing the panelists if you opt into a 3-member panel. So that may be part of your strategy thinking as well.
Okay. How many UDRP actions have you been involved in this year as either the filing attorney or the representing attorney, David?
I'd say this year, and I think of UDRPs as a piece of domain name disputes, whether it's federal court litigation or a threat of a UDRP or the actual filing, probably over a dozen or two.
Yeah. And when you say threat of a UDRP, is that like a cease and desist letter when you're trying to communicate with them before you even file anything, or?
Yeah, it's a UDRP and the claims in a UDRP can give rise to a court claim. I don't like to think of the UDRP segregated from the possibility of a lawsuit. So on either side, it's important to keep in mind that whatever happens with the UDRP may not be the end of it. There may also be a lawsuit. Very often domain name disputes start with a cease and desist and an attempt to work it out. And then from there, it may be UDRP, it may be, depending on how the ruling comes out and which side you're on, it may go from there to federal court. So the UDRP is a piece of or a procedure that's available when there's a dispute. Yeah.
Is there one particular, the cut and dry case, the black and white case where somebody's cyber squatting, the confusingly similar to my trademark, no rights to use it, and operating in bad faith, cut and dry? Is there one case on the flip side, one UDRP in particular, that comes to the top of your mind that reflects some of the issues that arise when using the Uniform Dispute Resolution Policy, and it's a really gray area?
It's tough to think of a gray area. Well, I think there are some cases we talked about where, when the domain name itself includes an additional word. I think that's the biggest gray area right now. Panelists have come out both ways, where looking at the domain name itself, whether or not the addition of a word is sufficient to distinguish the domain name or render it not identical or confusingly similar. I think that's that tends to be a real gray area. In terms of an open and shut or clear-cut case, I'm familiar with a number of cases where UDRP complaint has been filed, and when you look at the actual arguments or the underlying data, the trademark did not exist at the time of the domain name registration. So, we talked about that at the outset. If that's well established under the UDRP that you have to have bad faith at the time of registration, and if your trademark didn't exist, then it's not an appropriate a complaint for the UDRP. That may mean you have to pursue litigation, but the bottom line is that's not something that should be subject to the UDRP. And,
right, and a great example, public example in the domain name industry is Rick Schwartz's Save Me. There's a Brazilian, I believe, company that has a coupon type deal website where like a Groupon but down in Brazil, and it was saveme.br.com or .com.br or something like that, and Rick Schwartz had registered saveme.com years before that company, I believe, came into existence. I'm not familiar with all of the details, but basically the company approached him, tried to buy it. They couldn't come to an agreement, so the company filed a UDRP, and it was successfully defended.
Right, I read about that, and it struck me as an open and shut case where the domain name registration by that registrant predates the existence of the trademark. It's not something that should be subject to the UDRP. It seems like I see a report on at least one ruling of that type per month these days. It's something that to me is it's not appropriate for the UDRP. That doesn't mean, you have to look at what's on the website. Switching from the Rick Schwartz example to just think of another site. If the site itself includes the trademark and is, confusingly similar to the complainant's trademark, there may be a cause of action for trademark infringement, but that doesn't mean it's something that should be pursued through the UDRP.
Gotcha. So just because there may be a copyright or a trademark infringement doesn't mean that you have legal rights to the domain name and can go through the UDRP process.
Right, and the reasoning behind that is the UDRP was set up to address pretty clear cases of cyber squatting, where there are these other issues. Again, if there's a business dispute, or if you really need to look into the issue of, are consumers going to be confused, and is it therefore a trademark infringement? That's something that a court should look into, that you're going to need discovery, you're going to need motions, you're going to need to really develop the record and look into the issue, as opposed to the UDRP is really a truncated process where through a couple filings and some arguments and evidence, the domain name's transferred.
Right.
That type of abbreviated process is not appropriate for a larger dispute.
Yeah. Now, if I'm actually going to file a court case, that's going to cost me a lot more money, right?
Yeah, absolutely. So, and that's the advantage there is if you're on the plaintiff side, you have the potential to recover monetary damages, which for cyber squatting can be up to $100,000 in statutory damages per domain name. And you may have some arguments that are not available in the limited context of the UDRP, but you're right, it's going to be significantly more expensive, which is why most trademark owners, when possible, use the UDRP.
Yeah.
I should also note that the court action option is available for respondents as well. So we talked about if you are losing respondent in a UDRP case, then the domain name is not actually transferred until a period passes, and you've got the option to go to court.
Great. I'm going to ask you about that, what happens after the UDRP process. So hold that thought. So sure. I've seen decisions come through, I believe, I've seen decisions come through where Google Incorporated is the claimant. And so I believe Google pretty actively pursues domain names that include the Google trademark in the domain name. Are you familiar with those also? Have you seen them come through pretty regularly?
I have, yes.
Okay, so there might be domain names like Google Rebates or Google Search or Google this or that.com, whatever, in all the different domains. And I've seen actions come through with like up to 25 domain names in a particular case. If I'm Google, how many domain names can I file as part of one WIPO case?
I think you can file as many as you can find that are owned by the same registrant.
Okay, so that's the issue. It's the same registrant. I'm filing a UDRP case against a specific registrant, not a case of all domain names.
That's right.
Okay, and so let's say that I find one person that's gone out and registered 25 domain names. I still need to prove those three things that we discussed earlier, David. If I buy a domain name and I don't point it anywhere, I don't offer it for sale, the domain name doesn't resolve, somebody can't really prove that I have bad faith in registering them, can they?
I'd say generally it would be an uphill battle. I think it's going to depend a little bit on what the name is, though. So trademark rights are classified on what's called a spectrum of distinctiveness. On the one hand, you've got coined trademarks that are words that have just been made up out of thin air. Mm-hmm. So those are the strongest trademarks. And if you think about it, if your company makes up a word, you're the first person on the planet to come up with that word and use it in your business, then there's probably not a reason why someone else needs to own that new word as a domain name unless they've got some reason for it that would establish they've got rights or legitimate interests, or that their registration was not in bad faith or bad faith registration or use. As you move down the scale of trademark distinctiveness, you have to look at that issue. Well, if there's not a site up, well, why did they register it? What was the point? Can you, as the trademark owner, establish everything you need to be successful? So that really you've got to look at all of those pieces, including how the domain name itself relates to your specific trademark.
Yeah, but if I haven't been labeled a cyber squatter in the past, I haven't lost any UDRP cases, and I just registered them and there's nothing there. How can somebody prove something if I haven't exhibited any facts that they can cite?
Yeah, so if the domain name itself is an ordinary English word term, then, and I was your attorney, I would suggest, you need to think twice about pursuing that claim based on what you just said, that if there's no evidence of bad faith registration or use, it's possible that the words have some other meaning other than the trademark, then that's something you need to think about. If the domain name itself is that type of coined wording, the complainant or trademark owner would have to argue by inference that there's no possibly legitimate use.
Okay, so arguing by inference is okay. It's almost like I watch these TV shows of, the detectives, and it's circumstantial evidence, right? Like,
yeah, I think they'd probably still be in trouble if there's no content, no history of cyber squatting, there are lots of ways to argue by inference, but if there's nothing, it's a clean slate, and it's, you need some evidence to put before the UDRP panelist on each of those three factors.
And if I have no evidence and I cite some, from my layman terminology, some circumstantial evidence that, hey, it couldn't be anything else. So I'm trying to get them to infer that there's bad faith there. You've seen cases where that has actually won a UDRP decision?
Yeah, and particularly by default, where the respondent doesn't show up and say, well, here's why these words have this meaning to me, and here's why I did it. So the best decisions to me are where there's been a appearance by both sides, and the panelist is able to look at both sides' arguments and come to a reasoned conclusion. Certainly there are decisions out there where there was that type of argument, no one appeared, and it's transferred by default. Okay.
All right, so the process seems pretty simple. As the complainant, I will file the paperwork. The organization, if I file it with WIPO or NAF, they'll assign a panel, either one person or three person, depending on what I paid for. They'll review it. Might they ever just reject it without asking the respondent for a response?
If you have not complied with their formalities, so let's say you just sent them a check in your name and signed it, but didn't attempt to argue under the requirements of the UDRP, then they won't get to the point of assigning it and moving it forward. They'll reject it out of hand.
Okay.
Short of that, if you make an attempt at complying with the requirements, then they're going to assign it to a panelist for a decision.
Okay.
And then it's up to the panelist to decide, well, have you really met your burden? Have you addressed all of the substantive requirements?
So the panel, whether it's one person or three person, will read what you submitted as a claimant, and if it meets all of the three requirements, then they'll ask the respondent for their response.
Typically, as soon as you file, a case administrator will look at the complaint for the formalities. If you've satisfied all the formalities, then they'll institute the proceeding, make sure that it's been, for example, you have to serve it by email on the registrant. So then they'll institute the proceeding, send it again to the owner of the domain name or registrant, and let them know they've got 20 days to respond. Then, depending on the service provider, they may, after that response period, they may wait to provide the complainant with their reply period. But they wait for all of the papers to be filed before it's then assigned to a panelist, either one or three. So then think of it as both sides' arguments as a package are forwarded to the panelist to then review and render a decision.
Gotcha. And that's all the panel has is the claimant arguments, the respondent's arguments. They read them. They don't ever go back and get more clarification from either side?
I don't recall ever seeing them ask for clarification. The parties will occasionally file more papers.
Yeah.
The supplemental rules, NAF, I think you're allowed to file a response as the complainant if you pay a fee. WIPO, the panelist has the discretion of whether or not to consider your supplemental filing. Mm-hmm. I've seen cases where both sides continue to file papers. So, it's the panelist may or may not look at those, but that's it.
If I'm a respondent, can I pay a little extra money and get an extra 20 days extension to the process?
I don't know the answer to that offhand.
Okay.
I think it depends on the case administrator and the service provider. I know that in certain cases an extension can be obtained. I don't know whether you need to pay a fee to do that or not.
Okay, because 20 days, it seems like a lot of time, but 20, if you're out of the country, you had some vacation planned, you've got some big issue going on in your business, 20 days could be eaten up pretty quickly, especially when you need to work with an attorney to get your story straight, the facts right, and then put it down in paper.
Right, and I know that there are mechanisms for requesting an extension, and on a case-by-case basis, I think the extensions are granted.
Okay. So do you typically work more with the claimants or the respondents, or is it pretty fair mix between the two, David?
In my practice, probably more complainants. My background is as an intellectual property attorney, so I'm more on the complainant side. But within the last year, I defended Frank Schilling's name administration in a federal court litigation, so I do represent both sides.
Okay. And so when somebody approaches you and they say, David, I've got this problem with this other person that owns a domain name that's confusingly similar to mine, what is your role as the intellectual property attorney?
To take a look at the facts there and look at all of these things we're talking about. So when are there trademark rights or trade name rights? You do not necessarily have to have a federal trademark registration to use the UDRP, but you must have established trademark rights. So those can be common law or unregistered, but the issue really is when did your rights arise? So when did you establish them? When was the domain name registered and how is it being used? You really need to look at, well, who's the registrant? If it's a proxy, can you get behind the proxy service to figure out who it is, and look at all the facts surrounding the registration and use to figure out, well, who's got what argument and what's the appropriate course of action.
Mm-hmm. Okay, so you work with the client to ask all those questions that then bring into the light a lot of different issues which may support or not support the claimant, your client moving forward with a UDRP case if they're claiming?
Yeah, that's right. And sometimes those discussions end up in the conclusion, well, this is not UDRP. This is not even a trademark case. This is more of a business dispute. You know, we were formerly partners. Well, who should own this domain name? You know, I see more and more businesses where the domain names become substantial assets of the company. And then if the business partners go their separate ways, there can be an issue. Well, who owns that domain name? Is it shared? You know, and those types of disputes really should not be pursued through the UDRP. There are other things you need to look at. So is there a contractual issue or those types of things?
Yeah, so often just as a business owner, being able to talk to somebody who understands all of the legal intricacies can help you figure out the best way to be effective. And the best way to be effective may not be anything to do with the legal system, and it may just be to work it out on your own.
Yeah, that's right.
It makes sense. Okay, so we talked about burden of proof. If I'm filing a UDRP case, it is my responsibility to prove the three items that you initially talked about. The domain name is confusingly similar to a trademark of mine. There's no rights, and they're operating in bad faith.
Right.
All right. If the burden of proof is on the person filing the UDRP, is there ever a time someone should not respond to the UDRP because the claimant hasn't proven what they need to prove?
That's a good question. I'd say probably not, because there are certainly UDRP cases where if I look at them, I think, wow, you know, this is potentially something that should not have been pursued through the UDRP, but the respondent or registrant didn't appear and raise that issue. And while the panelists typically do not, and increasingly these days, do not just decide by default, there's that risk that when all that's before them is one side of the argument, that's all they have to consider.
Yeah.
The flip side of that is if it's that type of situation where you'd consider not responding because potentially the facts are just really bad for you, it might make sense to try and work it out. Reach out to the other side and try and reach some sort of settlement agreement, short of it going to a decision that's going to be associated with your name on the internet from that point forward.
Have you ever seen a case decided where the respondent did not respond, and the case was won by the respondent?
Yeah, and it's interesting. I think increasingly, and this is just my opinion from reviewing the cases, increasingly I think the panelists do look at the substance of the allegations even where there's not a response. And there are certain sort of red flag issues. The date of the trademark rights versus the date of the domain name registration. If you've got common law rights, have you sufficiently established that through a declaration or evidence? So there are certain hot button issues, or if to your point, if there's no content on the website, if the domain name's not resolving, where's the argument that there was registration and use in bad faith? So I think there are certain pieces that particularly will grab panelists' attention, and they'll find, even where there hasn't been a response, that the complainant hasn't met the burden. That's not always the case, but it seems to me like increasingly they're looking for those issues.
Yeah. Okay. So as we go through time and more cases are being filed, it seems like more of the panelists are gravitating towards, let's make sure that these critical legal issues are addressed by the claimant before we make a decision for them. And if they're not, then that's deciding it. But again, I think the thing that frustrates domain name investors the most is that there's no cut and dry, there's no black and white, there's no rules determined that all panelists will follow under all situations. The only rule is that there are 3 criteria that must be proven by the person filing the UDRP case. But even in some cases, I'm sure you can cite a number of cases where bad faith isn't proven very well. Right.
Yeah. And it's the interesting thing about the UDRP is in the U.S. legal system, we have the concept of stare decisis, where courts are bound to follow prior rulings. So the judges rendering rulings try and keep in line with the prior holdings, interpreting laws and policies. That concept, strictly speaking, does not apply to the UDRP. However, the panelists do look to prior decisions. They're not bound by prior decisions, but that's sort of the best you can do, is argue by analogy to prior decisions. But you're right, the panelists may well come to a different conclusion.
Yeah. All right. Can you estimate what percentage of UDRP actions are settled between the parties, either before a decision is made or, well, actually, that's an interesting point, before a panel is set, or even after the panel is set, before a decision is made?
I'm not aware of any statistics. I'll just say I've seen an increasing number settled. It seems like in recent years, more and more cases, particularly open and shut, are being resolved. To me, I think that makes a lot of sense for both parties. If you can work it out from the complainant's perspective, you get a refund on part of your fees. From the respondent or registrant's perspective, you avoid that decision. You avoid a finding that you violated the UDRP, which could come back to haunt you later. I think that that's a win-win situation for both sides if there's some possibility. And I've noticed a trend, I think, in more settlements prior to appointment of the panel. To answer your question about settlement after appointment, I don't see very many, because there's not much to gain at that point.
Because they're going to decide it even if you did settle it. Yeah,
and you can, you can try and stop the panel from rendering the decision, but as a practical matter, once the UDRP provider has appointed the panel and delegated the case to them, you can try and stop that from moving forward, but most likely they're going to go forward with the decision.
Yeah. What are the general costs of a UDRP, David? If I, let's say I'm a business owner and I don't know anything about the UDRP, clearly I can go over to NAF and I can go to the WIPO website and take a look at it, but I'm not going to, I'm going to ask the readers not to cite exactly what you're saying, but if I want to file a case, what does it typically cost? What's the adder for a 3-person versus a 1-person panel? What would I generally look for in legal fees of an attorney, or what should I budget for in legal fees of an attorney if it's relatively cut and dry?
I can tell you the filing fees, I know at WIPO are around $1,500 and slightly less than that at NAF per domain name. Each has a different schedule that the fees go up by the number of domain names you're including in your complaint, and then also by whether or not you ask, that's for a single person panel. The fees go up when you ask for a 3-person panel, but that's really the ballpark of what you're starting at. For the individual numbers, they vary by the service provider. So if anyone's interested, I'd suggest they just go to WIPO or NAF's website for their specific fee schedule. In terms of attorney's fees, it's going to depend on the complexity of the case, as with anything. If it's open and shut as a complainant, you're probably looking at a few $1,000s. If it's more complicated, multiple domain names or unregistered trademark rights or complicated domain name registration history or things like that, then it's going to go up from there.
Right.
As the respondent, the same thing. If the complaint is well done and the complainant has then met their burden or shifted their burden to you, then you need to rebut that. You're going to need to compile evidence and arguments. So that's going to take some time and money as well. The best response is going to include facts and sworn testimony through a declaration or affidavit in response. So while the process is going to be significantly less expensive than federal court litigation, it's generally not cheap either.
Yeah. So I would never think about suing somebody and filing a court case by myself without an attorney's help to navigate the process. Do you see people filing their own UDRP actions on behalf of themselves in layman's, terms and using a layman, application or filing document as opposed to using an attorney?
I do. I think I've seen an increase in those types of filings, and we talked about the reports that come out from WIPO and NAF on case filings, and To be honest with you, I most recently read the cases where there's a denial because those are the most interesting. The 85% of cases that are won are less interesting for me. And I have observed in some of those cases where there's a denial that more and more recently I've seen businesses filing them on their own, not necessarily through an in-house attorney, but just through a business person. And that's certainly possible and permissible, but you do still there's no lowering of the regulations or the requirements. You've still got to meet those 3 requirements, and you've got to establish them through facts and legal argument.
Yeah. Okay, that makes sense. So somebody goes through the UDRP process. Let's say the respondent puts in their response, and the panel determines that the claimant should win the case. And I'm using layman's terms because I don't know what all the legal terms are, David. So excuse me for that. But the claimant wins the case. What now happens for the respondent? What recourse did they have to try and keep the name, to argue it again, and I understand that when I register a domain name through, say, GoDaddy, I agree to their terms and conditions, which I haven't read in detail, but I'm sure say that I will be bound by the UDRP process if somebody, files a UDRP action against me for the domain name that I'm registering with them. So I've already agreed to that. What recourse do I have after I may have lost a UDRP case?
So you're right. Your domain name registration agreement, it will incorporate the UDRP by contract. So all ICANN authorized registrars are required to incorporate the UDRP in their domain name registration contracts. And then what that means is the UDRP really is a contractual-based arbitration system. You agree to be bound by any ruling from the UDRP. So if the panelist orders the domain name transferred, you are subject to that, but there's a hold period. So the registrar in question does not transfer the domain name until after that hold period has passed, which I want to say is 15 days, but it may be slightly different. But in that range, during that time period, you have the ability to file a court action. And then if you provide evidence that to the registrar that you filed a court action, then they will not proceed with the transfer order pursuant to the UDRP decision. Now, under U.S. law, the Anti-Cyber-Squatting Consumer Protection Act, or ACPA, which is a piece of the broader Federal Trademark Act, includes a provision that allows you to go to a U.S. federal court and ask for a declaration that you did not engage in cyber squatting. So if you are the losing party in a UDRP decision, that is the piece of federal law that you would invoke. You'd go to the court and ask the judge to give you a ruling that what you did was not cyber squatting. Then you'd pursue that claim and potentially others in the litigation.
Got it. Okay, so I have 15 days or somewhere around there, and I need to go to the courts, and I need to file either a counter claim against the domain name, or I need to file that I am not a cyber squatter. Is there a difference between the two?
There is. So it depends on the situation. In that situation, clearly you'd have the right to ask for a declaration that you did not engage in cyber squatting. So okay. Think of that as asking for the court to overturn the UDRP panel.
Okay. Because if I don't do that and I just say, no, they're wrong and I'm going to file a case to try and win the domain name back, the UDRP still stands, and it's a matter of public record saying that I lost this case.
Right. So it's always, once the decision's rendered, it's always going to be out there. But if you file the federal court action, the actual transfer process wouldn't kick in.
Okay.
So the federal court is not bound by the UDRP decision or bound to give any deference to it. So in essence, it's a new clean slate, and you'd make your argument there as to whether or not, if you were the registrant, whether or not you engaged in cyber squatting. That declaration, clearly you could pursue. you could potentially pursue a claim for reverse domain name hijacking, which is different under U.S. federal law than under the UDRP. So under the UDRP, you'll occasionally see a panel conclude that the complainant engaged in reverse domain name hijacking or attempted reverse domain name hijacking. That's really nothing more than a sentence in the opinion. It doesn't result in anything. However, under U.S. federal law, there's a cause of action for reverse domain name hijacking if your use of the domain name has been impaired somehow.
Right.
So if, let's say, as part of the UDRP process, the domain name was actually suspended so it wouldn't resolve and you lost money, or it was actually transferred prior to the UDRP decision, somehow your rights in the domain name were impaired, there's a federal cause of action for reverse domain name hijacking.
Okay. And at what point in the process, let's say that UDRP case was filed, I'm the respondent, it goes to panel, the panel sides in favor of the claimant, the panel orders the registrar to transfer the domain, I go to court and I ask for, I file that I'm not a cyber squatter, and I file documents to say that it was reverse domain name hijacking. At what point does the registrar have the right to cause the domain name not to resolve to my website, let's say? Or is it not defined?
It's hard to say. They shouldn't change anything until there's a determination either by UDRP or by the court. It's possible that they will have, and that's in the federal court context, that's really what leads to the reverse domain name hijacking claim. If the registrar, in response to representations by the claimant, which are unfounded, takes action and prevents it from resolving. Okay. Or let's say
the registrar should not take action until a decision has been made by UDRP at least.
I would think, yeah, that's the best protocol. There are obviously exceptions. So if a domain name is being used as part of a phishing scam or some sort of fraud, and it's clearly not a dispute, then I might counsel a registrar to go ahead and pull the plug, or even the registry to shut down the domain name so it doesn't resolve, because it's that type of situation.
Right.
But where you're dealing with a claim of cyber squatting and it's a different situation, then my opinion is that the registrar should wait for the UDRP decision or a court ruling, or the parties can always reach an agreement as well.
Yeah. Okay. So the UDRP process seems pretty cut and dry if the person is in the U.S., let's say. What happens when the respondent lives in a country other than the United States? Does that affect the process at all, or it doesn't, because the registrars are bound to ICANN's policies and the UDRP by association?
Yeah, that's right. The UDRP is incorporated into all generic top-level domain contracts and certain country code contracts. Other country codes have their own UDRP-like policy, which is, are very often similar. But regardless of where the registrant is, if the domain name is of an extension to which the UDRP applies, then it doesn't matter where you are as a registrant. As part of the UDRP, the complainant must agree to some jurisdiction for mutual jurisdiction. So that could be either the location of the registrant or the registrar. That means that, and the reason for that is if, let's say you've got a registrant and a registrar that are based in Europe, let's say the United Kingdom, and they want to challenge that UDRP transfer order, the complainant has consented to the jurisdiction of one of the courts where the registrant can actually go to obtain an order preventing the transfer.
Got it. So in some cases, it is actually advantageous to use the UDRP versus going to file a court case. So for example, if somebody has registered a domain name through a Bahamas registrar, and the claimant is in the United States, they can go file a court case. But if the the domain name registrant is outside the U.S., they really aren't bound by U.S. laws.
Yeah, that's a great example. So I've handled a few cases this year that involve phishing and phishing websites where it was clearly the name was direct on hit from one of my clients' names, and the website was then taking people's financial information, but the registrant was based in some cases Malaysia or Russia or China, where it's going to be difficult and expensive to pursue a court action, the UDRP, and the UDRP fits there because the domain name is a dead-on match, the site is a phishing site, it clearly fits, then that's a good case for the UDRP, and much, much preferable than me trying to go to court in Malaysia and explain cyber squatting and phishing.
Exactly. So if I was the business owner, I would have to go to Malaysia and try and explain the whole thing in court. Or here's a great example of using the UDRP for that instance. Okay, yeah, that makes perfect sense. What's the general timeline for a UDRP process versus a court case? From, let's say, the day of filing to a day of decision.
So usually for UDRP, it's about 60 days from filing to decision, give or take a few days. For a court case, it depends. Most cyber squatting cases are filed in the Eastern District of Virginia here outside of DC because the Anti-Cyber Squatting Consumer Protection Act provides for jurisdiction in the location of the registrar or the registry. So VeriSign's based in Northern Virginia, as is PIR that runs .org, and traditionally Network Solutions was based here, so many cases are filed in that court. That particular federal court is a lot faster than other courts around the country, and you may be in trial in 10 months in that court, versus if you're in another part of the country, it may be 2 years before you even see the judge. So the process could be a lot longer. Now, if you're dealing with, to go back to the phishing website example, there's some real problem with the site or some emergency, you can always go to court and ask for a temporary restraining order, which is an emergency motion or a preliminary injunction. If there's some emergency and some, ability to argue to the judge, you need to be heard right away.
So that's the quickest way to take a domain name down.
That's right.
Okay. So you get the judge to agree. He issues some sort of judgment, I guess, and then you take that to the registrar or the registry, and they temporarily disable the domain name.
Yeah, that's right. And so you'd have to establish to the judge that there's some emergency, some need for that type of order, and you'd probably ask for an order from the court directing the registry to make an entry in the zone file so that the domain name can't resolve anymore for the pendency of the case. That wouldn't be it. You'd always have to move forward with the case, but you have that option for asking for that in an emergency.
That makes perfect sense. All right, David, let's discuss a couple of really interesting UDRP decisions that have happened. One recent UDRP decision, I think it was just a couple of weeks ago, a popular registrar has a Whois privacy service. So for anybody that doesn't understand what Whois privacy is, you go register a domain name for likely an additional charge. That registrar, like a GoDaddy or a Moniker or Enom, will actually go out and say, we won't show your personal information on the domain name. When somebody does a lookup to see who the owner is, we'll show our privacy, and for people to contact you, they have to go through us. So it protects your name and your address and phone number and email address. So in this particular UDRP decision, Enom, their Whois privacy service, or actually the whole registrar, I need a little bit more information from you, was labeled as a cyber squatter, and they lost the UDRP action. Are you familiar with this case?
I did. I read the reported decision. So yeah, I think what's important to recognize, though, is that language, the notorious cyber squatter, was from the complainant submission. So very often what UDRP panelists do is they set out at the top of the opinion each side's arguments. So I think that's where we saw that language. I don't think the panelists actually repeated it, but you're right. Ultimately they found against them and ruled that the domain name should be transferred. It's an interesting case because UDRP, the majority rule is that if the named respondent has been found to have violated the UDRP previously, then that supports a finding in that particular case. Yeah. So there is that implication here.
And the respondent is whoever's listed on the domain name as the domain name registrant, which could be a Whois privacy service.
Yeah, that's right. And I don't, it's been my experience that most privacy or proxy services in their privacy or proxy agreement set forth that they're allowed to lift the privacy or proxy in the event of a legal claim. And very often you see that as an attorney for a complainant, I'll see a privacy service initially named, then they'll lift the privacy either when they receive your cease and desist letter or when they receive the lawsuit or the UDRP filing. But then that allows you to then substitute and name the actual registrant as the respondent or defendant. I don't know why that particular privacy service would not have lifted privacy so that their customer would be named. We see the result is that if you don't lift privacy, then you as a company end up standing in the shoes of your customer. And there is that, that issue for in terms of prior UDRP decisions and the implication for future cases.
Yeah. Now, what is that implication, David? If you get labeled as a, if you lose multiple UDRP actions, you can be labeled a cyber squatter. Is that the case?
It's taken as evidence that your use of the whatever domain name is in question in the subsequent case. It's taken as evidence that you indeed registered and used in bad faith.
Okay. So that could be a contributing factor to the third requirement in proving your UDRP case when you submit your paperwork.
Yeah, that's right, and it may, potentially even the second factor of rights or legitimate interests. It's, you could argue both, that it establishes a pattern, and that is a majority rule of UDRP cases that prior findings have some relevance there.
Yeah. Okay. Do you think this will have any effect on registrars' privacy services going forward?
That's a good question. I think the best policy is to be able to make sure that you've got the ability to lift privacy or proxy when appropriate. I don't know why that particular company would not have done that, and they may have their own business justifications for that being their policy. My opinion is I think we'll see more and more claims against registrars and potentially even registries with gTLDs going online in this type of situation, and a registrar or a registry is entitled to immunity for claims of intellectual property infringement if they're engaging in just their core registrar or registry function. But when the company is doing other things, ancillary services, so this is a good example, privacy or proxy, but extending to other things like parking or other types of monetization, auctions, or even domain name brokerage or recovery, when a company that may be an accredited registrar engages in those other types of services, then they move outside of that traditional registrar or registry immunity. So I think we're going to see more and more claims against companies operating in the space for those types of ancillary services.
Yeah. Okay, that makes sense. Okay, so another recent case that I thought was interesting was the UDRP action that was brought against a real estate agent who owned the name Living SoCal, which LivingSocial.com claimed was a domain name that they should own, that it was confusingly similar to their domain name, their rights, their trademark, things like that. And what they cited, I believe, was that www.livingsocal.com went to the real estate agent's website, but the non-www version, so somebody that just types in livingsocal.com, went to a pay-per-click site. Tell us about this case.
Yeah, really interesting ruling, and it sounded like the registrant didn't realize that was happening, and I think I could appreciate that he didn't realize that depending on his configuration settings in his domain name management panel, he wasn't getting all of the traffic to his actual legitimate website, his real estate business. That I guess that was a default setting that allowed for pay-per-click content on the one hand. To me, what that case turned on was he had rights or legitimate interests in that domain name, and he was running a legitimate business. He didn't register, and I think the panelists went so far as to move on to the third factor and also say there was no bad faith registration or use, and that this fact that pay-per-click content was displayed in the one hand was not dispositive, and the panelists believed him that he didn't realize that technically that was even happening because it was a configuration setting.
Yeah, I think I've done that on my website in the past as well, and it took a customer to say, hey, Mike, do you know that your website here isn't resolving when you don't type in the www? Like, it's not... Sometimes it is rocket science because the domain registrar's website is just so confusing to figure out. They don't make, these A records and C names very easy to understand. So why didn't... So it seemed like it was clear. Why didn't the panel say that Living Social, the company that filed the UDRP case, was trying to reverse domain name hijack this Living SoCal website?
Yeah, I think in the my impression is UDRP panelists are typically willing to do that if there's something clearly inappropriate. So the trademark didn't exist at the time of registration. There's, it's a business dispute, or there's a license, or there's something, but where it's really, on the face of it, whoever wrote the complaint should have known that they didn't have a complaint and they shouldn't have pursued it. Here, I think it's more of a gray area. I think it makes sense, the ruling from the panel, but there was this pay-per-click content. So the panelist, that's the situation where there's some arguments on both sides, so unlikely to be a finding of reverse domain name hijacking in that case.
Yeah. All right, David, this has been a great interview. Really shed a lot of light for me on the whole process and how decisions are made and what factors come into decisions. Here's the final question. The new gTLDs that everybody's been talking about, that thousands of applications have been filed for, that millions of new domain names will be coming online in the next few years. The gTLDs are going to be arriving. As an attorney, how do you see this affecting the intellectual property rights in the domain name industry with regards to copyright and trademark protections? What do you see coming down the pike? What do you advise business owners, and how do you advise investors to prepare?
Yeah, you're right. There's a lot out there. I think there's a lot of attention being paid to gTLDs. In my opinion, there's a lot of misinformation and a lot of apprehension as well. And it seems to me like every other day there's a new consultant that is moving into the space to offer some, life-changing services. So there's a lot going on out there. I think the bottom line is you're right. So there are going to be upwards of 1,400 new gTLDs going live over the next few years. I think there are really two takeaways for businesses. The first is, if you didn't apply, now's the time to take a look at that list. There's a limited time period to take action if there's a pending gTLD application that is a concern to you. That window is closing and will not come back. So I think everyone should take a look at the list and see what's out there. If they don't raise concerns, then that helps you see what's coming down the road. The second step, I think, is to start planning. Well, what's your approach going to be once new gTLDs go live? From both the investor side, where are you going to invest? Where are you going to make registrations? From a business perspective, well, where does it make sense to protect your name? Where should you register defensively? Where should you plan on taking action through UDRP or otherwise? So there are just so many, 1,400 is a lot. In the past, we've had a few gTLDs go online at a time, and you could sort of take the approach, well, am I going to register, am I not? I don't think you're going to be able to have that luxury with upwards of 1,400 going online, and we'll have to see how many ICANN can actually delegate in a given year. There's going to be a lot. So I think it makes sense to make your protocol and, start developing your strategy. So, for you, something like domain Sherpa.university may make sense. Something like domain Sherpa.shoes probably doesn't make sense for you to spend the money on on registration fees. And when you multiply that out by 1,400 extensions,
it put me out of business if I tried to register that many domain names.
That's exactly right. And I think that's going to extend to your thinking on protecting your brand online. So when all the gTLDs go online and someone else starts registering, if someone registers domain Sherpa.fruit, I don't know if that's an application, but let's say it was.
It wouldn't surprise me if it was.
You probably don't care, but if someone registers something like domain Sherpa.adult, maybe you do care. I guess it would depend on the content, but that's the type of thing, and I think it makes a lot of sense to develop that thinking or that strategy ahead of time.
Because I don't want to have to, because it's cheaper for me to register a domain name in the sunrise period because I'm the trademark owner of Domain Sherpa than it will be for me to potentially pass it up and then go through the UDRP for $1,500 filing plus attorney's fees to get it back later.
Yeah, that's right. So the conventional wisdom as a trademark owner, or which is just about any company that has a name that faces consumers, you're a trademark owner. The conventional wisdom is it's more efficient to defensively register during sunrise because that's going to cost a lot less, either through a resolving registration or very popular during the XXX launch was a blocking registration. So that was traditionally how companies protected their brands. But you make an excellent point. It's not going to be possible to defensively register through Sunrise or otherwise across all registries. You're going to have to make a judgment call. Which ones do you care about, and which ones do you let go and wait and see if an actual problem comes up through someone else registering.
All right, a lot to think about for business owners, for trademark owners. If you have a follow-up question for David, please post it in the comments below, and we'll ask him to come back and answer as many generic questions as he can. Clearly, he can't address your specific questions. In that case, you should, contact a domain name attorney or contact David Weslow directly. If you'd like to follow David Weslow on Twitter, you can do so at David Weslow, DAVIDWESLOW. We'll have a link to that Twitter account just below. David Weslow, partner at Wiley Rhine LLP. Thank you for coming on the show again, providing understandable and actionable UDRP information. And thank you for being a repeat Domain Sherpa.
Michael, thank you again for having me.
Thank you all for watching. We'll see you next time.